All right, thank you.
Thank you.
All right, next case will be Mootry versus Bethune-Cookman University. Morning. Before you sit down, let me ask you, will you two be doing both cases?
Yes.
Okay. And do you want to reserve time, the appellee for surrebuttal, or do you want to just do it the norm, if you would? Because the issue on the cross appeal is kind of intertwined with the issues on appeal. I don't know.
I can reserve 1 minute on each case, but I do agree with you on they're intertwined, and I probably won't use it,
Okay.
if that's okay with the court.
All right.
Good morning. May it please the court. David Vukelja, I'm here on behalf of the appellant. I originally appeared on behalf of Dr. Russell Mootry, a prominent educator at Bethune-Cookman University. He passed away during the course of these proceedings, and I now represent his estate.
Okay. How much time would you like for rebuttal?
15. I'd like to reserve 5 minutes if I could.
Okay, go ahead.
The first issue on appeal before this court is whether the trial court erred by denying Mr. Mootry's motion for partial summary judgment as to liability for Bethune-Cookman's breach of contract. The breach of contract aspect that's particularly pertinent in this instance is Bethune-Cookman had a specific sexual harassment policy that had very specific terms and provisions as far as the process that was to be followed in the event a professor, much less a tenured professor, should be accused of sexual harassment, which is exactly the nature of the charges that was brought against Dr. Mootry. And the reason why we were so bold as to ask for a summary judgment on behalf of the plaintiff was the testimony that was elicited, as well as the responses to the discovery that was obtained. The sexual harassment policy provided, for starters, that in the event a complaint, it all started with a complaint that never happened in this manner, was received, it would be referred to a faculty committee consisting of 5 people. That faculty committee was tasked with the responsibility of investigating the complaint, doing whatever inquiry, conducting whatever hearings, taking whatever testimony may be required, and then ultimately reporting to the president its findings and recommendations. Now, in this instance, what happened was that did not happen. That faculty committee was never formed. The requirement for the faculty committee is found in the faculty handbook. The trial court found that the faculty handbook did, in fact, comprise part of the employment agreement. Dr. Mootry had an employment contract, and he had a faculty handbook. And the testimony by both sides were that the parties would refer to both of them for the purpose of ascertaining what their respective obligations to one another were. The faculty handbook not only contained the sexual harassment policy and the requirements I just mentioned, it also incorporated the standards of the American Association of University Professors. In layman, translated for the purpose of these proceedings, what that means is the accused had the right to confront his accuser, to cross-examine witnesses, to have charges brought against him, to be given an opportunity to defend.
Did the handbook have language saying that this was not part of the professor's contract?
Yes, sir.
Okay. On your motion for summary judgment, were you asking the trial judge to ignore that language, or how did you want to deal with that language?
I wanted the trial judge to take into consideration the testimony from the president of the university that she had tried to comply with the handbook. She referred to the handbook. She was familiar with the handbook and thought that she was in compliance with the handbook.
All of those things.
Sorry.
Go ahead. You would agree then that it's a factual issue, it's your position that the facts were so clear the trial court should have granted summary judgment?
Absolutely. Absolutely, Your Honor. There was no dispute. As a matter of fact, later on, the trial judge entered an order when the court denied various summary judgment motions. It entered its order finding that on the basis of both parties resorting to the handbook throughout this process, that the handbook was deemed as a matter of law a part of the contract, and that this was the process.
The trial judge also found not necessarily the entire handbook, that would be a jury question, right?
I'm sorry, Your Honor.
Didn't the trial judge find that although the handbook was part of the contract, the trial judge didn't find that the entire handbook was part of the contract, correct?
I would presume that's correct. I mean, we were focused on the sexual harassment policy primarily, and the rights my client obtained or was entitled to under the AAUP standards.
So, counsel, anytime, just help me with your position here. Your position is that any time an entity follows its handbook, the handbook, as a matter of law, becomes part of a contract. Is that your position?
My position is if there is a contract and if there is a handbook, and if the handbook is used for the purpose of explaining the contract, then yes, sir, the handbook does apply and does govern. For example, in this instance, the contract itself, I believe the President herself said it was sparse with regard to any process that was to be followed, rules, regulations, things to be done. So when you have a handbook in conjunction with a contract, and there's a question regarding perhaps an ambiguity in the contract that someone's looking to explain, and you have the admission by both sides that they refer to the faculty handbook in such instances for guidance and to ascertain what they do, then yes, in that instance, yes, sir, I would say the faculty handbook is part of the contract. Now, what we also have in the way of testimony from from the President, Dr. Reed, was she specifically admitted during the deposition testimony that she knowingly violated. My man was one of 4 people simultaneously terminated. They all got the same notice of suspension. They all got the same notice of termination. They all went through the same investigation by the President's own investigator, for lack of a better term, because the faculty committee was never convened. But my point is, all 4 of these people went through the same process, but the President ultimately admitted she knowingly violated their rights under the handbook.
Wasn't the testimony more along the lines of they followed the termination process, termination for cause, rather than knowingly violating the rights?
That is what I call an after-acquired theory, after the President admitted she knowingly violated their rights. Because what happened...
The facts that they did, providing the termination letter, they did follow the procedure outlined in the termination for cause portion, correct?
No, Your Honor, I would respectfully disagree. Because they didn't follow the termination for cause. Had they followed the termination for cause, my client still would have had a pre-termination hearing that never happened. Now, what happened was...
How is that, though, not a factual issue for the jury?
Pardon?
Whether the termination for cause procedures were followed, how is that not a factual issue?
Because as a matter of law, the court is responsible for matters of contract interpretation, and if there is no ambiguity or no confusion, I would respectfully submit that the court is responsible for making those rulings it can to winnow down the issues, the actual factual issues to be decided by the jury. And in this instance, the trial court had ruled that the faculty handbook was a part of the contract. All right, but we never got an instruction to that effect. Because we never got an instruction to that effect, Bethune-Cookman was free to argue to the jury the very language you alluded to a moment ago when they said, look, it says right there, it's not a contract. We're not bound by any of this. But the court had already made a determination as a matter of law, based on the party's own conduct and their own reliance on the handbook, that the handbook was in fact part of the contract. So I would respectfully submit, no, it was not a matter of just Bethune-Cookman coming in after the fact, after the President's already admitted she violated their rights under the sexual harassment policy, then arguing, well, we didn't terminate him over there, we terminated him over here. Well, that begs the first question, which is, why are we ignoring the specific sexual harassment policy when the man's being accused of sexual harassment? Why are we opting instead for some general termination for cause language? And the only explanation given by Bethune-Cookman was, as far as they were concerned, what took this out of the sexual harassment umbrella, if you will, was the fact that there were 4 of these professors being accused of sexual harassment, that somehow the number or the multitude of professors that we're talking about took it out of the sexual harassment analysis and threw it into the termination for cause analysis. And I would respectfully submit, as a matter of law, first off, that makes no sense whatsoever, and it was undisputed by the president herself that she initially attempted to follow the sexual harassment policy and admitted that under that policy, she denied them their rights. Her explanation...
Yes. Is there a requirement for you to prevail to show that the breach of the policy, if you would, made a difference? And let me give you an example. Let's say you had a professor who shot and killed a student, all right? And so they get an immediate suspension letter, a termination notice, or whatever, and they don't follow the policy. And then before trial, by the time the trial has occurred, the person's been convicted of first-degree murder, or whatever. And it goes to trial. Do you just have to show they didn't follow the policy, or do you have to show that they failed to follow the policy and that was a material breach because, you know, the result would have been different if they had followed the policy? Do you understand my hypothetical?
I think what you're suggesting was, what if they actually did the deed, but you haven't been able to, but no one's made a determination.
But you didn't follow the policy, but you did the deed. Where does that? What's the jury supposed to find in that situation?
Well,
You
we
find that there's-
brought 2 claims in this instance. Claim number 1 was there was no cause for our termination because we didn't sexually harass anybody. Claim number 2 was that they failed to follow their termination procedures.
What are the damages for failing to follow the policy?
My man was wrongfully terminated. He should not have been terminated. Had they followed the policy like...
In the hypothetical, he committed wrongful conduct, right? So in the hypothetical that Judge Evander is asking about, what you're saying is not accurate. So let's stick with his hypothetical because I'm interested in the answer.
I mean, do you get damages, yes or no?
I mean, my common sense would tell me no if you've actually committed the deed. Now, in our instance, we have no proof of that at all. We have no proof that Professor Mootry sexually harassed anybody.
But in this case, if there was evidence that there was sexual harassment, the jury found it, then you would not be entitled to damages even if they didn't follow the policy, correct?
I think so. I think that's correct.
Okay. So let's focus on the evidence then on whether there was sexual harassment or not. And let's particularly talk about after acquired evidence. Is it your position that they cannot use any evidence that they didn't have at the time of firing?
Yes.
Okay.
Particularly in a contract action. I believe the authorities we cited in the brief show that after acquired evidence only arises in civil rights context and similar type cases. And specifically, with regard to the after acquired evidence, once again, my client has no opportunity to respond. So if what you're doing is coming in after the fact and saying, oh, we've got this evidence over here.
Client could have responded at trial.
Pardon?
Your client can respond at trial, right?
Well, why would there even be any need for a trial if we were given our pretrial opportunity to respond to these accusations to begin with? I mean, to have any meaningful right of review, which is what our contract provided for.
I agree. We can talk about that. We can continue talking about that, but I think Judge Evander is right. We should probably, given your concession a few minutes ago, we should probably focus on the evidence.
All right.
As opposed to the procedures, right? So you said your client wouldn't have an opportunity to respond to the evidence, but your client would have an opportunity to respond at trial, correct? And had an opportunity to respond at trial.
And did respond at trial. And the evidence was he hadn't sexually harassed anybody. He had not sexually harassed anybody. The only evidence that was brought in Dr. Mootry's case was Raquel Tapia, who said he made this remark in a social stratification class about women only being good for such and such, and that offended her. And
How is that not sufficient evidence?
because professors enjoy academic freedom in a teaching setting, which allows them to raise all sorts of controversial topics and what have you.
She testified that that wasn't the purpose of the statement.
Well, the fact of the matter is, it occurred in the context of a classroom setting.
So a professor can literally say anything he or she wants as long as it's in the classroom?
Pretty much. That's the whole purpose of the exchange of ideas. If he wants to start talking about the benefits of Nazism, then he's allowed to talk about the benefits of Nazism. If
But
he's
sexual harassment, there's a specific policy on that. It's forbidden, correct?
sexual harassment is forbidden, but I don't understand how discussing a topic constitutes you sexually harassing anybody, especially a topic in a classroom setting, especially in that classroom setting presupposes that the professors enjoy academic freedom with regard to their curricula.
But I think that's the point. The testimony was that it wasn't an academic statement, that it wasn't made in order to spur debate. Now, it's not for this court to say whether that's true or not. The fact finder would decide that, correct?
Well, but more importantly, the testimony was that that's exactly what it did. It spurred debate. The testimony in the trial and the testimony of record is that that's exactly what happened. You know, half the class started giggling, half the class started doing something else, and then they talked about, you know, these outmoded notions or this, that, and what have you. But my point is, that was the testimony that was elicited during trial. And then in addition to that, Raquel Tapia's other complaint is that she had to force her way between two professors in a hallway, and she found that to be objectionable. But in order to put that in context, what you have to understand is that according to her, these were two professors who had been hitting on her. But she also acknowledged in her testimony Dr. Mootry didn't know any of that. So here again, in any event, the fact remains that with regard to the sexual harassment policy, none of it was adhered to, none of it whatsoever. Instead of having the panel convened for the purpose of investigating these charges, the president has, I don't want to say her own, he was paid by Bethune-Cookman, but has a private investigator out there who conducts this investigation. And the way he conducts his investigation is total anonymity for anyone he talks to.
You're down to 4.5 minutes, just so you know. I don't know.
So am I into my reserve time?
You're into your rebuttal time, yeah.
Yes, sir.
Do you want to save the rest, or?
Then I'll stop there.
Okay.
Thank you.
Thank you.
Good morning. May it please the court, counsel. Good morning. My name is Scott Cole. I'm here on behalf of Bethune-Cookman. I'd like to address the court's second area of inquiry first, and whether there was allegations of sexual harassment directly against Dr. Mootry in the record, and the record is full of those allegations. First and foremost, Dr. Mootry himself admitted that a student hugged him. Now, that was his interpretation of what occurred, but he also admitted that if an inappropriate touching of a student is grounds for immediate termination, Bethune-Cookman has a zero-tolerance policy.
Are you saying that if a student hugs him, that's a violation of the policy?
I am saying that a jury could find that that was a violation of the policy, and it's up to the fact finder to determine
It's
whether
not the
that is.
Professors Act, right?
I'm sorry, Judge.
It's not the Professors Act.
I apologize. I still.
It's not the Professors Act, right? If a student comes up and hugs a professor, how's that the Professors Act? I looked at the policy. I'm trying to see how that's a violation of any of the policy provisions on that.
Well, it's a violation of the policy provision on page 28 and 29 of the handbook, which says, number 5, violation of university's policies regarding sexual harassment, discrimination, or harassment. Now, it's Dr.
Right, but
Mootry's.
the handbook also has a provision on what sexual harassment is. Can you tell me how that would violate that? The definition in the handbook on sexual harassment?
It would violate it because Dr. Lindsay, as well as Dr. Mootry, testified, Judge Evander, that any improper touching of a student is grounds for termination.
Where's the improper touching if the student is the one who does the touching?
Well, the improper touching is that's what Dr. Mootry described it as, whereas others described it as Dr. Mootry hugging the student. That's why it's
Who described that?
It was Ms. Kelsey described it, but I will address the court and say that the first opinion, or the first DCA, excuse me, first DCA, fifth DCA opinion in Mootry 1 did say that testimony was inappropriate because it was hearsay. However, in addition to that, the jury could determine that Dr. Mootry had no credibility and believe that he hugged a student based on other factors. Just because Dr. Mootry says a student hugged him does
If
not
you
make-
have no testimony that he hugged a student, and you have him denying that he hugged a student, you're saying that's substantive evidence that he hugged a student if the jury disbelieves him?
I am saying that. A jury can
That's
weigh
not the law at all. I mean, the law is you have to put on evidence of the point. The court, and then if he puts on counter evidence and the jury rejects it, that's fine. That's the jury's finding. But you got to have evidence in the first place.
Well, in addition, I respectfully state that the jury was free to weigh Dr. Mootry's credibility and determine that the student...
Right. And if they reject his testimony, then you have zero evidence here and zero evidence there.
Well, in addition to that, then I'll move on to other evidence that's in the record.
Okay, go
Dr.
ahead.
Mootry testified that he heard rumors about sexual harassment in the Department of Social Sciences, where he was the dean for many years. Dr. Mootry testified that he heard rumors that the other three individuals who were terminated with him, Yuka Waluli, Yuha Keme, and Negron, were sleeping with students. And Dr. Mootry testified he did nothing about it. That is a complete neglect of his duty, which is one of the factors that he can be fired for under his faculty contract. So that's also direct testimony from Dr. Mootry himself that he violated...
Which provision is that?
Pardon me?
Which provision does that violate?
He violated the provision regarding sexual harassment. Well, in the contract, Judge Eisnoglet says malfeasance, contumacious contact, neglect of duty. He can be fired for those three things.
Neglect of duty wasn't mentioned in the termination notice, though, right?
Pardon me?
Was neglect of duty included in the termination notice?
No, the termination notice did include, however, Judge Sasso, it included moral turpitude, violation of ethical code, conduct in violation of law or commonly accepted standards of morality, and allowing professors to, hearing rumors that professors are sleeping with students as a dean of the School of Social Sciences, and doing nothing about it, I submit to this court, and that is contained in the termination letter, is a violation of accepted standards of morality, a violation of ethical
Well,
conduct.
how hard would that have been to put in the termination letter?
It was in the termination letter.
No, you had general terms, which could have 1,000 things fit into them. But I mean, how difficult would it have been to put in there, other people engaged in sexual harassment, you were aware of it, and you took no action?
I'm certain an attorney probably could have put it in there, Judge Evander. I would admit to that.
Let me ask you about the closing argument. The idea of telling the jury, the university had other evidence that you do not have. Are you suggesting that was a proper argument and that the objection was properly overruled?
I'm suggesting that the argument was not grounds for a new trial. It's probably a comment that shouldn't have been made. It was a harmless comment.
Counsel, it wasn't a comment. It wasn't a comment. I think that's part of the problem. It turned into the theme of closing, or one of the themes.
I disagree with you, Judge Eisnoglet. It was a fleeting comment. It was one statement, and immediately thereafter, counsel stated that he believes he wins because they complied with the handbook. So it was one comment. It was one sentence in the closing argument. That was all it was.
Well, isn't there also a statement that it wasn't fair to the university, that they were limited by what evidence they could put in?
Well, I think it was also a statement that Mr. Vikelja made, and he talked about the evidence, and he talked about all the sidebars, and he talked about all the times they went up to the court, and the court had to be very careful about what
But
evidence
his
it let in or
statement
not.
was just an apology to the jury for all the time they spent being shuffled in and out as they argued things. I mean, the trial counsel's comment on behalf of the university was there's other evidence that the university had that you don't have, and it's kind of unfair to us that you don't get to hear that. I mean, I just think that's highly improper.
Well,
And the judge, this wasn't a situation where the judge sustained the objection and then denied a mistrial. This is a situation where the judge overruled the objection, thereby suggesting to the jury that Oh, you can consider that the university had other evidence that you didn't hear.
And no other evidence was mentioned. It was one comment. It
Counsel,
was-
wait a minute, maybe I'm misreading this, right? But counsel makes the statement,
Correct.
there's an objection, and the trial court overrules it. And then, after that, counsel proceeds to make it a theme. Counsel says, I'm going to play that game. Is there sufficient evidence? I don't have to prove this to you. I can't show you everything. You haven't seen everything. That was after it was overruled, and then. And you know what? When that happens, change the question, right? Divert the ball to another question so that what we are asking you to do, they're asking you all to disregard the judgment, the decision that was made by his peers, the president of the university, outside Learn Counsel, and all the other people involved who, in all fairness, have the benefit of more information than you because of the system we're in here. And they want you to disregard that. It wasn't one statement, was it?
Well, it was the one statement in that sense, one paragraph, yes. It was one.
Well,
group of
I'm
things,
looking
but-
at 3 paragraphs.
Well, it wasn't the theme of the closing argument. It wasn't the entire closing argument. The closing argument was, and the case was, there was cause to terminate or to.
Counsel, my question was that the entire argument? My question was didn't that turn into a theme of the closing argument? A theme.
I respectfully disagree with the court. It did not turn into a theme. The theme of the argument was that there was sufficient cause to terminate Dr. Mootry.
But you concede it wasn't just one comment, right?
Well, it was, that's what I intended to say to the court. And I
Trial
apologize,
counsel
but
continued down that road after the objection was overruled.
He did say that, yes, we have evidence you don't have, and so did the folks who made this decision. Yes, he did say that. More than one statement. Yes, I do recognize, and the court's correct on that. But however, the theme of the closing argument and the theme of the whole trial was there cause to terminate Dr. Mootry? Not only the things I mentioned earlier that Dr. Mootry did, but Raquel Tapia talked about sexual harassment by Dr. Mootry. Lorraine Butler-Hope talked about how Dr. Mootry asked her out on dates and harassed her and went to her house. Paul McComb's testimony was in the record prior to the summary judgment. He didn't testify in this trial. He testified in the other trial that we're going to hear in a moment. And he talked about how Dr. Mootry was at a dinner where the professors were showing nude pictures of students on a cell phone, and these are all professors.
That didn't come in this trial, right?
No, but it was in the record evidence prior to the summary judgment.
All right,
which is
well,
why
let's
I
talk
mentioned-
about, okay, I understand the summary judgment, but there's also an argument that directed verdict should have been granted. But as far as the sexual harassment, so what the jury heard was that a student hugged him. What the jury heard was that he made the comment in class that Ms. Tapia testified, that the incident in the hallway with the 2 other professors.
Correct.
The professor who previously, when she was a student, had been asked out.
Yes, and asked her out when she was a young professor as well.
As a professor as well.
And showed up at his house.
All right, anything else?
The hallway, I think, did Your Honor mention the hallway?
Hallway
Yeah,
incident.
the hallway incident. And then that was at trial. That was a trial. And also the evidence I mentioned about Dr. Mootry hearing things in the department as the dean and failing to act in any way whatsoever.
All right.
So that was the cause.
Let me ask you this. There's an issue on after acquired evidence, if you would. The idea that, the university put on evidence at trial, incidents that they may not have been aware of at the time they fired the professor. Looking at research on that, there doesn't seem to be a whole lot out of Florida. What's your best case on that's permissible evidence?
Well, from a factual standpoint, and I agree with you, Your Honor, there's not a lot of it on Florida. From a factual standpoint, this evidence was, at least some of the evidence was told, the evidence from Raquel Tapia about the hallway incident and the classroom comment was told to Ms. Kelsey, who did tell it to the investigator. And that was part of the report, which was part of the reason he was fired. So in that sense, it wasn't after acquired evidence.
Okay.
Certainly the dating the professor and student some years before, that was evidence that was not there at the time of the termination.
What are your best cases that that's permissible?
The best case is, again, is I don't think it falls into after acquired evidence because it was.
Well, but like the professor that it was after acquired. So in that situation, What's your best evidence?
The cases we relied on in our brief, I think there's really not a lot of cases in Florida on it. So I don't have a case that's that specific, and most of the evidentiary cases are very specific as to what type of evidence is permitted or not.
You haven't found a case in Florida either adopting or rejecting the after acquired evidence doctrine in a contract case like this, have you?
No.
Okay.
I wanted to also comment on we talked about the cause evidence. I also wanted to comment on the process evidence. And I think that there's been respectfully several misstatements here. And certainly I'm not accusing counsel of doing that purposely. First of all, Judge Evander, your question was, did the trial court find that portions of the handbook were not part of the contract? And I believe that's what the trial court did find. Second, Judge Sasso, and I agree with your question, there was no knowingly admission by President Reed that they did not follow the faculty handbook. The statement was, and the entire theme of the trial was that we followed pages 28 and 29 of the handbook, which includes sexual harassment. And on pages 28 and 29, you're entitled to a suspension pending investigation or hearing. That's what the title says. And then the language says investigation, hearing, and determination of charges. You're entitled to be informed of the reason for termination and effective date of termination. Advise the faculty member they have 20 days to ask for an administrative hearing, and give them an administrative hearing. So the jury, that evidence, that was a fair reason why summary judgment was denied, and the jury was allowed to.
Do you agree with your opposing counsel that the evidence, it was undisputed below that the handbook is part of the contract?
I don't, and I would cite to Judge Evander's first question of counsel that it says in 3 different spots it's not part of the contract, and President Reed testified on numerous occasions that it was a guidance. Was not part of the contract.
What about the issue that there's no issue of material fact that the party's conduct after the contract expressly incorporates a handbook?
Well, we would submit that there is an issue of material fact in the record, but I do know the trial court did find that, so we tried the case on the handbook being part of the contract. And that's one of the reasons we brought up on a cross appeal, that the summary judgment on that. But I do admit that that's what the case was tried on.
Let me ask you this. They argue in their brief that because this issue wasn't raised on a cross appeal on Mootry 1, if you would, that it's been waived. What's your response to that?
I don't believe it's been waived because the case was retried. The court allowed us to, they could bring up the summary judgment. We could bring up a summary judgment. There were new facts in the record. The new facts in the record included the trial testimony. And I don't think it's law of the case because it obviously wasn't before the 5th ECA, and they never commented on it. Speaking of
Mootry 1,
Sir.
They discussed the attorney's testimony and how proper that was. They've alleged that y'all did not comply with Mootry 1 as far as the professor being allowed to give testimony that, in essence, that she reviewed Mr. Brewer's report and, recommended termination, found that there was enough there in the report. I mean, didn't we suggest in Mootry 1 that was improper?
Your Honor, do you mean the lawyer, Ms. Kwiatek? I think, did Your
Right.
Honor say professor? I apologize.
You're right. Attorney Kwiatek.
Okay, yeah, Your Honor, I think Mootry 1 said 4 things. The Brewer report stays out, and it didn't come in. Kelsey could not testify that Mootry hugged a student and grabbed her buttocks. Reed could not testify that a student told her another student was having sex with Dr. Mootry. And Ms. Kwiatek could not do 3 things. Those things are, first, that the university complied with the contract and handbook, and she didn't do that. Number 2, Kwiatek could not testify that the university followed proper procedures, that the university had cause to terminate Dr. Mootry, and that's the 3rd thing, and that the university was, actually, and this ties into the 3rd one, the university was appropriate in terminating him. She didn't testify to any of that. In fact, there's a passage that we put in our brief where trial counsel said, I'm not going to ask her any of those 3 things. What I'm going to ask her is what she did in the case. Now, in their brief, they argued that she did not participate in the investigation. Well, that's a little bit misleading, respectfully, because she did participate. She was involved in consultation with the president. She was ensuring that due process was followed. She wrote the termination letter. She arranged for the faculty hearing, and she was intimately involved with that entire process. So she didn't tell the jury how to decide the case. She didn't tell the jury the university followed this or that. She told the jury what she recommended. The university then did what they did, and it was up to the jury to determine whether there was a material breach of the contract or not. And the jury found that there wasn't, contract and handbook in this case, and the jury found that there wasn't. So she did not violate the strict confines of what this court previously said in Mootry 1 in any way, shape, or form. She was a fact witness and testified as to fact issues.
Okay, but the question was asked, did you review any evidence provided by Bo Brewer before making your recommendations to the university? She said yes. And that report obviously did not come into evidence.
Correct.
So the implications, obvious that, that the report suggested a basis to terminate.
Well, she was asked what she did, and that's what she did. And the issue was, they brought up two issues. First, did they terminate him for cause? Was there evidence of sexual harassment? And so we had to defend against that allegation, and she had to be able to answer what she did. Yes, I reviewed it, and I made a recommendation. Now, whether that was appropriate or not, or the jury found that the facts are sufficient to support that allegation, that's a different issue.
The problem I see with that testimony is when you tie it in with the closing argument. So Brewer's report doesn't come in. The attorney testifies, I reviewed the report, and I recommended termination. Then on closing argument, the jury gets told, we had evidence that you didn't hear. And, you combine those two, to me, the inference to the jury is Brewer's report gave grounds and we didn't hear it. But we can consider it because, after all, the judge overruled the objection. That's why I think there's a real problem tying those two together.
Well, Judge Evander, in response to that, there was no comment on any evidence. There was no evidence outside the record said. And counsel did say, as Judge Eisnagel pointed out, that there's other evidence you can't hear, but he never said what that evidence was. Okay. And the jury couldn't have considered that evidence because the evidence was never put before the jury.
It's almost more powerful when you say, hey, there's all this evidence out there, but you don't get to see it. It's not fair. And then counsel said, they want to disregard that. That's not fair. That's not fair to the process. It's not fair to the Bethune-Cookman. Implying that, boy, there was a plethora of evidence that you don't get to see, jury, and it's not fair that you don't get to see it. I mean, I would suggest to you perhaps that's more powerful than actually telling the jury what the evidence was.
I would agree in certain cases, perhaps it is, but in this case it's not, because the jury was given ample evidence of not only rampant sexual harassment throughout the entire
But counsel, how do we know what the jury based its decision on when we have this type of argument? They're being invited to decide the case on information they don't have. So how do we know that they decided the case on information they did have, or if they decided information on the case on information they did not have?
Well, we'll never know that, and we'll never know that in any case. We certainly can't get in the minds of the jury.
Well, it wouldn't have been an issue had counsel not made the argument.
I agree with that, but I think in this case, none of these would have been issues if they hadn't been argued. But I think in this case, there's ample evidence to support the jury's verdict and the jury finding that there was no material breach of Dr. Mootry's contract. And I see I have about
You've
actually,
used
I'm
up all
20
your
seconds
time.
over.
Yeah.
I'll waive my rebuttal time, and
All
I'll
right,
ask
thank
the
you.
court to affirm, given the facts and overwhelming evidence that the process was followed and there was evidence of sexual harassment by Dr. Mootry. Thank you.
Thank you. All right, you got about 4 minutes and 21 seconds, approximately.
Throughout the course of this trial, Bethune-Cookman did everything it could to get the Brewer report in front of the jury, short of handing them the actual pages. Brewer was allowed to testify at length. He was allowed to get into the minutia regarding his investigation. Kelly Kwiatek was allowed to comment on that investigation. Kelly Kwiatek didn't render any opinions, but Kelly Kwiatek testified as to what she recommended and why. And again, throughout the course of this proceeding, what Bethune-Cookman did was succeed in bringing back, in perhaps a more powerful fashion than just putting it in front of them and moving on, all of the matters that this court said were off limits as far as the Mootry, what I call the Mootry 1 decision. With regard to the after acquired evidence issue, I believe we've probably canvassed the whole universe with regard to those cases. If there's more cases out there.
When you say the universe, you mean the Florida universe?
Yes, sir. Yes, sir.
Well, should a jury, when they're looking at whether a termination was wrongful, be constrained to determining whether the evidence submitted to the university was sufficient to support a termination, or should they be asked to determine whether it was in fact wrongful?
Whether it was in fact wrongful, because the prior goes to the state of mind of the actor, that being Bethune-Cookman, which this court specifically said in Mootry 1 was no justification for the Brewer report having come in to begin with.
Well, then wouldn't it be appropriate to present after acquired evidence to the jury to help them determine whether it was in fact wrongful?
Well, we have what I call a procedural due process claim, for lack of a better word. The after acquired evidence obviously didn't exist when my man was supposed to be utilizing or making, utilizing whatever administrative remedies were being made available to him pursuant to the contract.
Let me ask you this. There's some out-of-state case law that, says an employer can put on the after-acquired evidence, and the rationale that they use is, look, the employee should not benefit from the fact that the employer did not discover a basis for cause termination until afterwards. What would be your response, your counter-argument to that?
The after-acquired evidence effectively guts the administrative remedy that the employee is given as part of the contract to begin with. I'm sorry that more evidence comes up later on that might be compelling or this, that, or what have you. But if you're going to allow an administrative remedy, and as part and parcel of that remedy, you're supposed to be providing the employee all the information he needs in order to properly defend.
Well, the U.S. Supreme Court has said in a case where the lawsuit was based on a statutory cause of action, discrimination.
Yes, sir.
And then the employer raised as a defense that they found afterwards other grounds to terminate for cause. And the Supreme Court said, there's a public reason, if you would, to not let the employer escape liability here because we want to prevent discrimination. But that evidence can be used on damages, to mitigate damages. So, that's contrary to the procedural due process, if you would, but you have that U.S. Supreme Court authority.
I recognize that it exists. All I can tell you is, to my knowledge, it's confined to age discrimination and civil rights acts. The rationale behind that, I don't, I can't speak to. But here again, in a contract setting where we have contract rights, and those rights include the administrative remedies that were granted, that whole bundle of process that's right there under the sexual harassment chapter, to do otherwise, to just say, well, now we're bringing in this because it turns out we find out you did this, this, and this, is to basically rewrite the contract, which is absolutely prohibited.
All right, your time is up as well.
Your Honors.
Chris,
Thank
now
you.
we go right to your next case. And if you want, you both can, focus on the differences, but in this case, and what's fact specific to this new case.
Oh,
And I'm not even going to try to pronounce your client's name.
Ukuwalulu.
Of course.
Took a lot of practice. Once you try it a few times, it kind of rolls right off the tongue. In any event. Well, the primary variation between the two cases is the after acquired evidence. In Ukuwalulu, it was much more prominent than it was in Mootry. Don't misunderstand me, it was still after acquired evidence. But in this instance, what we had was we had testimony that was brought forward, once again, because the Brewer report was excluded. And here again, once coupled with Dr. Reed's admission regarding not following the sexual harassment policy, and then emboldened with this court's decision that confirmed that the Brewer report is hearsay and was inadmissible from the get-go, then my contention was we were entitled to summary judgment. Bethune-Cookman brought nothing new or different. So on that basis, it's our contention we were entitled to summary judgment.
Counsel, you said...
Does your after required evidence argument rest on the terms of the handbook being incorporated into the contract and the sexual harassment due process requirements?
Well, I believe the after acquired evidence rule kind of turns on the cases that we cited, but I see in the comments or in reading those cases, part of the rationale behind it is that, you know, when you're talking about a contract action and you're talking about after acquired evidence, then you're essentially rewriting the contract, which brings us back to the conversation we just had. It's like, okay, I've got this administrative remedy that I'm allowed to utilize before I resort to going to court, you know, and Bethune-Cookman has contractually agreed that I'm going to be entitled to that remedy. Now, are they simultaneously going to be allowed an unwritten proviso that says, oh, by the way, regardless of whether we allow you that remedy or not, should we find out other things that we don't know now, we'll be allowed to bring them up whenever we want, notwithstanding the fact that you've got this opportunity to challenge this termination right now.
So it's your position that this discussion is difficult because I think you said that you're only aware of after acquired evidence cases being when there's a statute involved, but there are cases even more broadly applying the doctrine to contract cases, even applying it even more broadly than the ones that apply to a statutory case. And I understand that you're not familiar with those; they're outside of Florida. But is it your position that then that those cases are wrong, and that in order to apply that doctrine in a contract case, the contract has to actually incorporate the doctrine?
It's my contention that to try to incorporate that law for the sake of creating an exception or a disclaimer, if you will, to your administrative remedies is rewriting the contract.
Well, let me ask you this. There's the basic tenet that, when you have a prior breach of a contract, basic contract law, right? The party who breaches first, then the other party doesn't have to perform. I mean, right? So the prior breach. Does that have to be written into a contract for it to apply?
No, sir. I mean that's Florida law, and there's any number. I mean, if your client, of illustrations of cases.
Let's assume for a moment that your client had engaged in dozens and dozens and dozens of clear sexual harassment. It was just I know that's not the case here, but let's just say that it was basically undisputed that your client had engaged in numerous instances of sexual harassment. The only issue was Bethune-Cookman didn't know about it at the time of the termination, right?
Yes, sir.
In that case, how would that not be a prior breach or an initial breach by your client? You say the handbook is part of the contract, right?
Handbook is part of the contract.
And so if your client is undisputedly committing sexual harassment, but Bethune doesn't know about it, isn't your client in breach and Bethune just doesn't know he's in breach yet?
Well, if Bethune-Cookman wants to charge him or accuse him of the breach, my client is still entitled.
No. That doesn't change whether your client's in breach. Bethune doesn't know that your client's in breach, right? But undisputedly, in my hypothetical, your client is in breach because he's committing. I'm asking you, is he in breach if he's undisputedly committing sexual harassment?
I suspect he would be in breach. The question is, what does it do to his remedy? I don't know that it does anything to his remedy.
Well, fair enough. I guess that's the next question. But you concede in that hypothetical, your client would be in breach.
If my client sexually harassed anybody, he would be in breach of his agreement.
Okay.
If Bethune-Cookman wanted to accuse him of that, so be it. If they gave him the particulars and an opportunity to defend and he lost, so be it.
So in this case, your client could be in material breach of the agreement, but Bethune-Cookman would still be obligated to perform on its side of the contract?
Yes.
With regard to the issue of damages, in other words, they fire him for cause on day one. for a basis that they don't prove, but sometime during discovery, on day 60, they find something that is for cause. Would his damages then be limited to back pay from day 1 to day 60, or how does that work?
Focusing on this contract, my client's faculty contract and his faculty handbook, my answer to that would be no.
Yeah, but the U.S.
Absolutely
Supreme
not.
Court says it can be used to mitigate damages, so I'm just trying to figure out.
Supreme Court, in the context of, I believe it's an age discrimination case, believe they did determine that that could be taken into consideration for the purpose of damages. I can't tell you what the policy reasons for that are, or what they may be. Let me hasten to add, in this context, these people, well, in any event, Dr. Ukuwalulu wasn't given an opportunity to respond to anything. So while I enjoy examining the netherworld of what sort of rights Bethune-Cookman would be entitled to, were they to learn that they had done something wrong, the fact of the matter is, Dr. Ukuwalulu wasn't given any information about anything. So I don't know to what extent any of these matters might have been discovered or might have become a topic of conversation or might have entered the analysis. I don't know, because the fact of the matter is they preempted Dr. Ukuwalulu's rights altogether, as they did Dr. Mootry's as well. And so consequently, you're being put to the task of saying, well, what if? Okay, well, and the reality in this instance was we weren't told anything.
Now, Professor McComb, I believe, he was not, Professor McComb,
Yes, sir.
that was not after acquired evidence, correct?
No, sir. Apparently he existed, and it's my understanding he spoke with Mr. Brewer. Now, again, we weren't provided the Brewer report. We weren't provided what McComb had to say. McComb is after acquired evidence as far as we're concerned, because, again, he's brought up after the fact during trial.
Let me ask you this. Would the sexual harassment policy prohibit, let's say, a dating relationship between a professor and a student if the student was not in the professor's class?
No.
Okay. Only if the student was in the professor's class?
I don't even know that that rule is there, but it's definitely frowned upon. They keep talking about a position of power, meaning a professor has some authority over the student or the authority over grades or this, that, or what have you. And so, like I say, that
Well, a professor is in a position of power and authority over a student in the student's class.
absolutely,
Right.
absolutely.
So
Yes, sir.
are you saying that the policy would permit the professor to date the student if the student was in the class, or would prohibit it?
I'm saying that consenting adults can do what they want, notwithstanding the professor-student relationship, where it starts becoming much more of a gray area is in the context in which the professor has some position of authority over the student, or some control, or can put the student in some jeopardy. And that's typically a student that's in his or her classroom or otherwise answerable to the professor. The Ukuwalulu argument, for the most part, is pretty much identical to the Mootry argument. Again, the after-acquired argument becomes a little more focused because Aisha Young, I don't believe, ever spoke to Mr. Brewer. Raquel Tapia never spoke to Mr. Brewer. Mr. McComb, I believe, did speak to Mr. Brewer. But here again, these people weren't brought out, if you will, in opposition to Dr. Ukuwalulu until the litigation started, because until, he was terminated, and his termination was upheld without Dr. Mootry or Dr. Ukuwalulu knowing anything about the specifics. So with that, we pretty much raised the same arguments that we did in the Mootry brief, and we would respectfully request that this court enter judgment on our summary judgment for Ukuwalulu. And with regard to we have the Mootry 1 decision that also comes into effect. And so...
Counsel, we didn't have the same closing argument issues in this case, correct?
No, sir.
Suggesting that there was additional evidence
Right.
that the jury didn't see.
Yes, sir. I believe that's correct. Thank you.
May it please the court. Obviously, the court's heard argument for, I guess, about 40 minutes now or 50 minutes now on these issues. The difference is, and Judge Eisenhower, to follow up on your point, there was an allegation that was improper denial of a motion for summary judgment. That was in Mootry. Admitting hearsay and irrelevant testimony. That was also in Mootry. Failing to properly instruct the jury, and denial of the DV motion, which is essentially part and parcel of the summary judgment motion. There was no special interrogatory verdict form issue in Ukwalulu, and there was no closing argument issue in Ukwalulu.
Let me ask you, same question. Does the policy of Bethune-Cookman prohibit a professor from dating a student if the student is not in their class?
It's my understanding it does. It's a zero tolerance policy.
Okay.
And it violates not only the provisions on page 28 and 29 of the handbook, but also 52 to 54 of the handbook.
Because Professor McComb's testimony, he indicated that the appellant in this case did admit to dating or having sex with students or whatever, but I'm not sure whether it indicated whether those students were in his class or not. So that's the reason for my question.
I don't recall if they were or not. I think Professor McComb said they were in his classes, and I do recall that. But in addition to that, Judge Evander, Professor McComb also said that in addition to these other three professors at a dinner that Dr. Mootry was also in attendance, were having sex with students, they also were showing pictures of naked students, female students, on their cell phone, including very compromising photos of various areas of their body that were clearly inappropriate. So not only was it the statement that they were having sex with students and dating students, but it was also the photos that Professor McComb saw himself. That was clearly not after acquired evidence. I would also assert that if the court is correct, based upon counsel's admission, that if there was a violation of if there was a violation of the policy, even though Bethune-Cookman may not have been aware of it or not, that Ukwalulu as well as Mootry were clearly in breach, and it does mitigate their damages because they're in breach at that time, and if they're in breach, then the contract provisions and the termination for cause as well as the suspension should be upheld. With that said, the significant differences, the court's aware of them, and I'll ask that the court affirm.
All right, thank you.
Thank you.
Any rebuttal?
No, sir.
Okay. Thank you both. Interesting case, and we will take about a 15-minute recess, and again,